Welcome. Today, we'll break down Section 135 of the Companies Act 2013, which makes corporate social responsibility, or CSR, a legal obligation for certain companies in India. This law is unique because it requires profitable companies to actively contribute to social welfare, making India one of the first countries to mandate CSR by statute. In this video, we'll explore which companies are covered, what CSR means for both Indian and foreign. Section 135 applies to a wide range of companies, private, public, listed, holding, subsidiary, and even foreign companies with a business presence in India. But not every company is required to comply. The law sets specific financial thresholds. If a company meets any one of these in the previous financial year, net worth of 500 crore or more, turnover of 1,000 crore or more, or net profit of 5 crore or more, CSR provisions become mandatory. All companies that meet the financial criteria must comply immediately. There are specific exemptions. For example, specified if public and private company are exempt from CSR requirements for the first 5 years from the commencement of their business as per a government notification. This exemption allows new companies in international financial services centers to focus on establishing their operation before taking on CSR obligation. It's important to check. Foreign companies are also covered under Section 135 if they have a business presence in India. This includes branch offices, project offices, liaison offices, or any other business activity in India. Even though these companies are incorporated outside India, if their Indian operations meet the financial threshold, they must comply with CSR requirements. Importantly, the financial calculations for foreign companies are based only on their Indian business operation, not the. According to Section 2, of the Companies Act, a foreign company is any company incorporated outside India that has a place of business in India, whether through a branch, project, liaison office, or any other business present. If such a company conducts business activity in India and meets the CSR threshold, it must comply with Section 135. This ensures that foreign entities benefiting from Indian market also contribute to the country's social development. Foreign company net profit is calculated as per Section 198 of the Companies Act, but only profit arising from Indian operations are considered. The global profits of the parent company are not included. This calculation method ensures that the CSR obligation is fair and proportionate to the company's actual business footprint in India. It's crucial for foreign companies to maintain clear financial record of their Indian operation for accurate CSR. A foreign company meets the CSR criteria, it must constitute a CSR committee. This committee should have at least 2 persons, one resident in India, authorized to accept notices on behalf of the company, and another nominated by the foreign company. There is no requirement for an independent director in this case. The committee plays a key role in formulating CSR policy, recommending expenditure, and monitoring implementation. Foreign companies, like their Indian counterparts, must spend at least 2% the average net profit of the last 3 financial years, calculated only from Indian operation, on CSR activities in India. This spending must be on activities listed under Schedule VII of the Act, such as education, healthcare, rural development, and environmental sustainability. The law ensures that CSR funds are used for the benefit of Indian society. Foreign companies must include details of their CSR activities in the balance sheet filed under Section 381 (b) and submit required documents to the Registrar of Company. They must also disclose CSR activity in the prescribed format. This ensures transparency and allows regulators and the public to track how foreign companies are contributing to social welfare in India. CSR funds must be spent within India on activities listed under Schedule VII of the Companies Act. These include education, healthcare, rural development, environmental sustainability, disaster relief, women empowerment, and contributions to government relief funds. Spending CSR funds outside India is not allowed. This ensures that the benefits of CSR spending are felt within the country. If a company does not spend the required 2% on CSR, the treatment of the unspent amount depends on whether it relates to ongoing projects. For ongoing projects, the unspent amount must be transferred to a special unspent CSR account within T-state. For other cases, the amount must be transferred to a specified government fund within 6 months. Penalties may apply for non-compliance, making timely action essential. Let's look at practical example. Suppose a US company opens a branch in India. Over 3 years, its Indian branch earns net profits of 6 crore, 7 crore and 5 crore. The average net profit is 6 crore. The CSR obligation is 2% of 6 crore, which equals 12 lakh. This amount must be spent on CSR activities in India, demonstrating how the law works in real scenarios. Recap: CSR applies only if financial thresholds are met, calculations are based solely on Indian operation, and spending must occur within India. A separate CSR committee is required, and reporting under Indian law is mandatory. These points form the backbone of CSR compliance for both Indian and foreign companies operating in India. Every company required to constitute a CSR committee must disclose its composition in the board's report. This includes the names and designations of each committee member, the number of meetings held, and attendance details. The annual report on CSR in the prescribed format must be attached to the board's report. This ensures transparency and accountability in CSR governance. CSR committee has three main functions: formulating and recommending the CSR policy, recommending the amount to be spent on CSR activities, and monitoring the implementation of the CSR policy. The committee ensures that CSR activities align with the company's objectives and statutory requirements, and that funds are used effectively for approved projects. CSR committee is responsible for formulating and recommending a CSR policy to the board. This policy must specify the CSR activities the company will undertake, ensuring they fall within the areas listed in Schedule VII of the Act. The committee plays a strategic role in identifying focus areas that align with both statutory requirements and the company's value. Committee must recommend to the board the amount of expenditure on CSR activity. By law, this is at least 2% of the average net profit of the past 3 years. The committee allocates funds to specific projects and recommends how the budget should be distributed between ongoing and new initiatives. The board gives the final approval. Monitoring is a crucial function of the CSR committee. The committee reviews the implementation status of approved projects, ensures funds are used for their intended purposes, evaluates the progress of ongoing projects, and checks compliance with statutory timelines. This ongoing oversight ensures accountability and effective use of CSR funds. CSR committee acts as a policy formulating body, a recommending authority, and a supervisory mechanism. While the board retains ultimate responsibility, the committee ensures structured governance and statutory compliance in CSR implementation. This division of roles helps maintain checks and balances within the company. Board of Directors has several statutory duties regarding CSR. After considering the CSR committee's recommendation, the board must approve the CSR policy, disclose its content in the board's report, and ensure the policy is displayed on the company's website. The board is also responsible for overseeing the actual implementation of CSR activity. Transparency is key. The board must disclose the content of the CSR policy in its board's report and ensure the policy, committee composition, and approved projects are available on the company's website. This allows shareholders and the public to understand the company's CSR objectives and activity. Board must ensure that the activities listed in the CSR policy are actually undertaken. This includes overseeing the execution of approved projects, ensuring funds are used for their intended purposes, and monitoring compliance with statutory spending and reporting requirements.